Begin tonight here in Nigeria, where a court has convicted the detained separatist leader Nnamdi Kanu of terrorism charges and sentenced him to life in prison. The verdict was delivered and the sentence passed in his absence after the leader of the outlawed indigenous people of Biafra, or IPOB, was ejected from the court after repeated interruptions. Mr. Kanu, who's been in prison since 2021, denied all the charges against him.
The death penalty globally is now being frowned upon by the international community. Consequently, and in the interest of justice, I hereby sentence the convicts to life imprisonment for the said counts 1, 4, 5, and 6 instead of death sentence. Life is sacred to God. With respect to count 3, he is hereby sentenced to 20 years imprisonment without no option or fine. For count 7, he is sentenced to 5 years imprisonment without no option or fine. To extend the mercy, I hereby order that the sentence shall run concurrently. And due to the nature of the offenses that borders on terrorism and the attitude, violent nature of the defendants that I have taken judicial notice. The last adjourned date, he was so unruly and expressed violence, even was about to beat the security officers there. This morning, he repeated same.
And that's Justice Omotosho there, who delivered that verdict and passed the sentence on Nnamdi Kanu earlier today. With more on this, I'm joined now in the studio by Arise legal correspondent Godfrey Eshemogie. Good to see you, Godfrey. You were, of course, in court. Give us a sense of how the day unfolded in that courtroom today.
Yes, good evening, Charles. My pleasure to be here. Well, it started in a normal way a court proceeding would have commenced. Everywhere was calm, everybody was there to listen, to get the verdict of one of the most keenly followed cases in Nigeria in recent history. But the matter got to its head when Kanu made an attempt to have the court stay proceeding, particularly with respect to the judgment itself. He wanted the court to stop any further hearing with regard to what will culminate in the verdict that we eventually had. When his 3 motions were denied him, he knew his fate was sealed. At that point, all hell let loose. And then we saw the drama we saw on air this morning. He started screaming that the judge doesn't know the law and all that. And in fact, that smacked of a conduct that wouldn't have been for someone who is on trial for the magnitude of case he had against him. One would have expected that he would have comported himself better, to avoid what eventually became his fate today. Would have expected some remorse, show of remorse, to get sympathy from Nigerians and the international community who have been following this case pretty keenly. The judge repeatedly mentioned his unruly attitude. Of course, that equally, made him, perhaps, decide. I'm sure he didn't actually. That equally, didn't help his case, to be very frank. But then, of course, the matter ended the way it did. Kanu's portrayal of his attitude today wasn't what anyone would have expected. He had said there wasn't any valid charge against him. One would have expected his approach would have been tactical, would have given sufficient grounds why he felt the charges against him were invalid, not take the line of action he took, particularly shouting at the judge in open court. That was absolutely reckless, unruly to say the least.
And do you think perhaps the circumstances were made perhaps worse by the fact that he didn't have proper legal representation with him? I mean, he dismissed his legal team.
Well, he dismissed that on...
Because they might have advised him different.
He dismissed them on paper.
Yeah.
But in practical terms, those legal representatives, at least about 4 of them, were still present in court. They were his consultants, quote, consultant in court. They followed him all the way, and they gave him all the legal advice he would have required to see the case through. So he, being a representative of himself, was merely on paper, because all the guidance he would have needed was given to him.
But it would have been a little bit different if he had that representation, because they would have been speaking on his behalf, in which case that outburst probably wouldn't have taken place earlier today.
Yes, of course, he would have done. But then, you know, there's this thing about Nnamdi Kanu. He's almost his short fuse, if you ask me. And his approach to things of this nature, involving even hitting some of his counsel, telling them what to do. You hit a counsel, tell him you're not doing this in the way you should have done it. So that tells you he's this person who is independent-minded. So whether they are there or not, whether they're representing him or not, what he wants to do most likely will be his line of action ultimately. So.
And I mean, that is particularly important. We're not just banging on about it, because the judge actually mentioned it and said that as far as he's concerned, that's an indication that Nnamdi Kanu has violent tendencies and therefore needs to be contained.
He needs to be contained. So, of course, you heard the outcome. You know, the judge actually couched this in his judgment, repeatedly mentioned that his unruly behavior was consistent, was constant. He did that repeatedly. In fact, that had been the case since the days of Binta Nyako, the judge who was handling this case before she recused herself, before she withdrew and handed it over to Justice James Omotosho. Right from then, it was the same thing. And in fact, the same thing that played out in today's court hearing played out there. He stood up and told Justice Binta Nyako that he doesn't have confidence in the way she was handling the matter. That prompted her to say, well, I don't need to continue in this matter. So she recused herself, and that was the end of it. And
briefly, what was the reaction in court when the judgment was delivered and the sentence was passed?
Well, in the courtroom, the conduct was calm, was controlled. But outside the courtroom, his consultants, I choose to put in quote, said they were going to appeal. They faulted the action, they faulted the decision of the verdict of the court, and raised ethnic sentiments, saying this is a judgment against certain tribe, that the government is against certain tribe, and so on and so forth. So they're going to appeal the judgment that Nnamdi Kanu wasn't guilty, that he was being trialed, on falsified charge. So he felt he wasn't guilty, that the sentence was an overkill.
And in fact, those words were coming from the former lawyer turned consultant, Aloy Ejimako, who said the judgment was a travesty and was not consistent with the evidence that was laid before the court. So what happens next? His former lawyer says they'll go on appeal, but he doesn't formally represent Mr. Kanu any longer, does he?
He doesn't. Well, talking about evidence, Kanu, to set the record straight, Kanu didn't set any evidence before the court because he didn't defend himself. He didn't open his defense. The court relied on the evidence of the prosecution. Kanu stood his ground that the prosecution had no case against him. So Aloy Ejimako mentioning evidence brought before the court is more like a misrepresentation of the actual things that eventually played out during the trial. Kanu called no witness, brought no evidence to defend his case or to defend the position of the prosecution. So to say there was evidence brought before the court and all that, that's a clear misrepresentation.
But I mean, you're a bit of a legal eagle yourself. Yeah. I mean, would that be grounds for appeal? I mean, would he have a leg to stand on? I know you can't predict what the appeal court is going to do, but just purely in terms of analysis of the fact that he never actually got to present his substantive sort of defense case, would that be basis for appeal?
That would have been a basis for appeal if they hadn't got it wrong with respect to the aspect of the repealed law. They got it wrong at that point. So if you take the matter on appeal, it's looking most likely that the appeal will fall apart. It's already a case that is doomed to fail. I'm not trying to preempt the decision of the Court of Appeal.
Obviously, yes.
Because they've placed not something on nothing, as it were, something on nothing. So it'll be highly unlikely that the appeal court will want to now dig up evidence where there's none. So in this case, an appeal will only end one way. I'm not trying to preempt the court. Let me be clear on that.
And how long has he got before he has to lodge an appeal?
90 days.
Right.
Clearly, 90 days.
So it's got to be done in 3 months, or?
Yes, in 3
or
months.
the court, this judgment today, and the ruling will stand.
Yes, and I don't foresee him waiving that right to appeal, because that would be pretty costly.
Indeed.
Yes.
Godfrey, thank you very much indeed.
Yes,
and thank you for your very good reporting for us during this entire sort of saga of Nnamdi Kanu's trial. Godfrey Shemoge is Arise legal correspondent. Good to see you.
Thanks, sir.